Perfect. And I think we have people at the table that understand a lot of this stuff really well. So I will end my rant and come back to asking some questions. And I think the first one I would start with is when we talk about dealing with clemency and things we can do, I think too often we make it binary choices. We talked earlier about retroactive application of those types of things. But are there ways where if we pass something like sentencing guideline reform that we can work that into a presumption of existing cases? Because we have moving forward and looking back. And if we get into an all or nothing situation, we always run into a situation where we may get nothing. And just to get some structure, and as an example, anybody who had a nonviolent drug crime with a sentencing guideline above X, and we changed that law, I mean, in order to put it into the system with a presumption towards it, does that make sense?
I think if you're asking, if I'm understanding correctly, Congress has given directives to the Sentencing Commission in the past, but almost every directive Congress has ever given the Sentencing Commission is to increase sentences. But you have the power to give directives to lower sentences. And so if the question is, should it be appropriate to give directives to lower sentences? I would say absolutely. And I think that, and also fixing mandatory minimums, because I think, you see both of those as the kind of inputs that create these problems are the mandatory minimums, and then you can have excessive guideline cases.
Well, and I appreciate that, because I think one of the things you see on minimum mandatory sentences is where they fall on the guideline chart. One of the things the First Step Act did that I think is hopefully going to show a lot of long-term results is how we allowed for the safety valve. And I mean, getting a Class B misdemeanor deferred imposition of sentence when you were 18 years old for having a joint used to be where you wouldn't qualify for the safety valve anymore, and how we're dealing with those issues. Now, so I'm gonna just switch a little bit. When we're dealing with this moving forward, and not so much in the clemency area, what are some things we can do to work towards either because it's usually the minor people in these cases, and there are just so many perverse incentives for somebody with a decent case to not go to trial, whether it's a 5K1, substantial cooperation, or qualifying for the safety valve. Are there ways we can appropriate those things so they can actually be utilized and also work towards people's ability to go to trial?
I'm sure Professor Barco will have comments on that, but just briefly, I would say that a couple things to look at relating to that would be the conspiracy law, and the way that conspiracy built on top of the way we use the weight of narcotics as the proxy for culpability, it leads to the problems, a lot of the cases that I, as a federal prosecutor, and you as a federal prosecutor, saw.
Oh, I was a defense attorney. I was on the side of righteousness and goodness.
And you saw the same thing, though.
We did.
Yeah, but that's one thing. Also, insofar as there are other laws that we have in the federal system that bootstrap accomplice liability into sentencing, we need to review those, and that's something that would really use the attention of this body.
Well, and before go ahead, ma'am.
I would also add, looking at the trial penalty that's often put on a person who exercises their constitutional right to a trial and doesn't accept the plea agreement. We need more transparency around plea agreements and how and whether they're offered and to whom, so that we'll know how people are choosing and or being coerced into taking pleas.
Well, and I think, and I've seen that just on the ground, it's not that it's necessarily sometimes people don't want to take responsibility for their actions, they just don't think their actions quite correlate with 375 pounds of methamphetamine because of what you were talking about the total weight of the process. So, I mean, again, that's not always binary. Yes, am I guilty of something? No, should I be going to prison for 37 years? I mean, so having the ability to do some of that post-sentencing, which would get me back to my point of, we've done an okay job of making guidelines discretionary instead of mandatory, but I still stand by we're appointing federal judges for life, and we need to give them a little more control over their courtrooms, and that could work into a clemency scenario as well.
Could I just add that if you wanted to address the plea bargaining issue, one of the directives, for example, you could have is that you would allow defendants to challenge relevant conduct, and it would not count against acceptance of responsibility. It's a kind of precise way to deal with the problem that you're talking about, because right now the department frequently tells people that you cannot get acceptance of responsibility if you're going to challenge relevant conduct on appeal, and that makes a big difference, and it creates all kinds of issues with whether or not people can challenge things later. So I do think that, that's the kind of, it's more micromanaging of things that happen over at the commission, but Congress has done that a lot over the years, but always in the direction of severity. And so I do think it wouldn't be inappropriate to do it in the other direction, and also to emphasize you want more role adjustments.
Thank you, and thank you all for being here.